Is Colorado a right-to-work state under Colorado labor law? Labor law and employment law suffer a lot of confusion because there are a number of terms and phrases with specific legal meaning but are often misunderstood by employees and employers to have a different meaning. As a result, employees in Colorado and other states often misunderstand their employee rights and employer often misunderstand their duties in the workplace. Right to work is one of the least understood terms within labor and employment law. It is commonly confused with at-will employment and misunderstood within the proper context. Colorado is not a right-to-work state under its labor laws, but understanding what that term means is as important as knowing the answer to that question. Today's post will try to clarify what right to work means under Colorado labor law. What does right to work mean under labor and employment law? Right to work developed a meaning under labor law to mean those states that prohibit employers and unions representing their employees from requiring employees to join the union as a condition of employment. Union security agreements generally require that employees within the bargained unit must be union members or must pay a partial dues payment to the union for representation without membership. Proponents of union security agreements understood that requiring union membership would strengthen the financial and human support behind the union. It would also ensure greater labor peace between workers and employers by avoiding fights, sometimes violent, over whether to keep the workplace unionized. Opponents recognized that if unions could not ensure all workers in a bargained unit supported the union financially or personally, that the unions would have fewer resources to agitate into other workplaces. Brief history of right-to-work laws. Early labor law in this country left open the opportunity for employers and unions to bargain over these security agreements, but anti-union lobbyists in the early 20th century lobbied for laws to prohibit them. During the New Deal, Congress passed the National Labor Relations Act of 1935, NLRA, and also referred to as the Wagner Act, authorized union security agreements. The NLRA authorized employers to enter into 4 arrangements. Closed shop. Employees must be a member of the union as a condition of employment. Union shop. Like a closed shop, but the employer may hire non-union employees, but as a condition of employment the non-members must become union members within a set period of time. Agency shop. Employees do not have to be union members, but non-members pay agency fees which are partial dues to cover the cost of representing non-members in the bargained unit. Open shop. Employees do not have to be union members and the employer cannot fire employees for choosing to join or not join a union. In 1947, anti-union lobbyists prevailed with the passage of the Labor Management Relations Act over President Truman's veto, which severely limited these arrangements. The LMRA bans closed shops entirely. It amended the NLRA to allow union shops and agency shops subject to state laws which may ban one or both. State laws banning union shops or agency shops are right-to-work laws. What is the difference between right-to-work and at-will employment in Colorado? Right-to-work and at-will employment deal with 2 different issues under labor and employment law. At-will employment is an employment condition in which the employment relationship exists as long as both employee and employer want it to continue. Right-to-work and at-will employment intersect as issues when an employee works under a collective bargaining agreement. The standard for termination, at least from the employer, is a just cause standard, rather than at will. An employer can only fire an employee within the confines of the CBA and must provide the employee an opportunity to be heard and oppose the termination. Often a CBA will establish an arbitration or other hearing procedure for this purpose. An employee cannot be fired for any other reason or without industrial due process. Because Colorado is not a right-to-work state, an employee may be hired immediately into a collective bargaining agreement and not suffer at-will employment. If the employee is not within a bargained unit, then the employee is an at-will employee, or has an individual employment contract, regardless of the state's union shop laws. If you believe you have a wrongful termination claim, then you should contact a Denver employment lawyer right away.